Good morning. Today we are going to analyze one problem question on covenants. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's go to the problem question. Titmus was the owner of the registered freehold of Willow, a large country house set is extends in extensive gardens. Willow grounds includes Furner Fields, a cricket pitch, and a pavilion. In 2007, Titmus sold Furner Field to Botham. As part of their conveyance, Botham agreed to the following covenants. First one, not to allow any structure on Furner Fields to fall into disrepair. Second one is about the timing, to use the Furner Field only for cricket matches to be played between the hours of noon and 6 p.m. And the third covenant, to allow the current owner of the willow to present the cups at the annual cricket award ceremony organized by Botham and his successors in title. In 2015, Titmus died and left the willow to his son Henry, who, like his father, is a cricket fan. 6 months ago, Botham sold the Furner Field to Rachel. Rachel immediately installed floodlighting and started to use a Furner Field for cricket matches between the hours of 6 p.m. and 10 p.m. Rachel has since refused Henry's request to repair the pavilion a leaking roof, which was damaged by a tree that blew down in a recent storm. Last week, Rachel placed a notice in the village newsletter announcing that the vice president of Ladies English Cricket Board will be presenting the cups at this year's cricket award ceremony. We have to advise Henry. To advise Henry regarding the enforcement of covenants against Rachel, we will analyze the situation in terms of the benefits and burdens of the covenants established when Furner Field was sold. First one, a benefit of covenants, a passing of benefit to Henry. Henry, as the heir of Titimus, inherits the benefits of the covenants related to Furner Field. Under the Landlord and Tenant Act 1925, LPA 1925, specifically the Section 78 and 79, the benefit of the covenant can pass to successors in title if it touches and concerns the land. Covenant A, it's required the upkeep of the structure which directly affects the enjoyment of the willow. Thus, it can be argued that this benefit touches and concerns the Henry's land. Covenant B, it restricts the use of the fauna field to cricket matches during specific hours. This also touches and concerns the Henry's enjoyment of his property, as it ensures the cricket matches do not disturb his residence during the evening. Covenant C involves the presentation of awards, which does not touch and concern the land in a traditional sense, potentially complicating the enforcement of this covenant. Passing of burden to Rachel. The question of whether the burden of covenant can pass to Rachel is more complex, particularly for covenants that are positive in nature, like A and C. A covenant A, this is a positive covenant. It's requiring the action, like the maintenance of the pavilion, which cannot typically run with the land at common law, as mentioned in Roney versus Stephens. However, it may run in equity if Henry can establish that Rizal has assumed the burden through the sale agreement, or if the burden can be enforced through other equitable doctrines. Passing of burden to Rachel. Covenant B. This is a restrictive covenant, and while it may not run at common law, It might pass in equity. The condition of it being the registered under the Land Registration Act 2002 could be crucial, particularly under the Section 79, which allows for the burden of a restrictive covenant to be enforceable against the successor is if properly registered. Covenant C, similar to the A, this is a pass-through covenant and is unlikely to be enforceable against racial at common law. It may not be enforceable in equity either, as it does not touch and concern the land. Equitable relief. Given the breaches of the covenant by racial, for covenant A, Henry could seek an injunction requiring the racial to repair the pavilion, arguing that the upkeep directly affects his enjoyment of willow. If he can show that Russell has assumed this obligation, he may find equitable relief. For covenant B, Henry can argue that Russell's use of Furnace Field for cricket matches after 6 p.m. is a breach of covenant. He may seek an injunction to enforce compliance with specified hours. For Covenant C, since the Razel plan to disregard this covenant, Henry may seek a declaration that covenant is enforceable, though the lack of direct connection to the land may hinder this. Let's look into the case laws. In Turk versus Mokshoy, this case established that restrictive covenants can bind the successor in title if the original parties intended for the covenant to run with the land. In our case, the covenants made by Botham likely intended to continue with the land, thus binding the ratio. Asherberry versus Oldham Corporation. This case clarifies that a positive covenant, example, repairing the pavilion, cannot run with the land. Hence, while racial may not be legally compelled to repair the pavilion under the original covenant, her refusal to maintain the property could be challenged under the covenant A. Whereas in Roney versus Stephens, this case supports the principle that covenant must be a negative, a restructuring the use of the land to bind the successors. Thus, the covenant A and B could be enforceable if they are deemed negative in nature. LPI 1925, these sections detail the creation and enforcement of covenants. Section 78 is particularly relevant as it allows for the benefit of a covenant to run with the land, supporting the Henry's claim to enforce a covenant against racial. The Contract Rights of Third Parties Act 1999, Section 1. This act allows the third party, like Henry, to enforce the contractual terms if the contract expressly provides for that or if the terms confer a benefit on the third party. This may allow also support Henry's positions if the covenants were intended to benefit the owner of the will. Passing the benefit Henry's portion. Henry inherited the benefit of the covenants when his father Titmus passed away. Under Section 78, LPA 1925, the benefit of the covenant run with the land, meaning Henry can enforce these covenants against racial if they touch and concern the land, as established in Smith and Snipes, Hall Farm Limited versus a River Douglas Catchment Board. What are the relevant cases? In Federated Homes Limited versus Mill Lodge Property Limited, it was confirmed that the benefit can pass to successors if the covenants are intended to run with the land. The covenants here clearly relate to the use and maintenance of Furner Field. Thus, they touch and concern the land. The next one is the passing the burden, the Rachel's portion. Rachel, as a new owner of the Furner field, is bound by the covenant if they run with the land. However, according to Roney versus Stephens, the burden of the positive covenants, like maintaining the pavilion, does not pass at law unless there are specific legal mechanism in place, which do not appear to be satisfied here. The covenant to maintain the pavilion could be seen as a positive covenant while Racial would not be bound to unless an exception applies, like common hold or the mutual benefit. A covenant and not to allow structures to fall into disrepair. The racial's refusal to repair the pavilion violates the covenant requiring the maintenance. In Tulk versus Moksha in 1848, it was established that restrictive covenants can bind the successors in title if they are intended to run with the land. Since this covenant was intended to benefit the land, that is willow, Henry can likely enforce it against the racial. Racial use of the furnace field for the matches until 10 p.m. It breaches the covenant. The principle of Astorbury versus Oldham Corporations in 1885 holds that a positive covenants like maintenance do not run with the land, but the restrictive covenants like the time of use can be enforced. So in the same thing there are two things. One is the maintenance, that is a positive, and the working, the timing is the time of use is a is a negative one. So Henry can argue that the racial actions violate these restrictive covenants. Racial's notice about the award presentation may not honor the original agreement. Under Section 1 of the Contract Rights of Third Parties Act 1999, while Henry may not be a party to the original agreement, he can rely on this provision to argue that the intent of the covenant was to confer a benefit on him as the current owner. So, what are the potential remedies for Henry? The first one is injunction. Henry can seek an injunction to compel Rachel to repair the pavilion and cease using the Forner fields outside the agreed hours. This aligned with the findings in Federated Homes versus Mill Lodge Properties in 1980, where the court upheld the right to enforce the positive and negative covenants. A second will be the damages. Henry may also pursue damages for any loss incurred due to racial breach, especially concerning the disrepair of the pavilion. The principles from Roney vs. Stephens in 1994 on damages for the breach of covenant could support this claim. Notice of breach. Henry should formally notify Rachel of her breaches, referencing the covenants and the potential for legal action if compliance is not met, as seen in Haywood versus Brunswick, PBS in 1883, where the proper notice was critical in enforcing the covenants. So we are going to summarize the advice. Covenant A. Henry can argue that Rachel is in breach of the covenant by failing to maintain the pavilion. Although this is a positive covenant, he may seek to compel her to carry out the repairs, leveraging the principle of maintaining the property's condition. Henry could seek an injunction requiring the Rachel to repair the pavilion, arguing that upkeep directly affect his enjoyment of willow. If he can show that Rachel was assumed this obligation, he may find equitable relief. For the covenant B, Rachel's extension of match hours violates this covenant. Henry can enforce this restriction and seek an injunction to prevent further violations. Henry can argue that racial use of Furness Field for the cricket matches after 6 p.m. is a breach of covenant. He may seek an injunction to enforce a compliance with the specified hours. Covenant C. Henry has a strong argument that Rachel must allow him to present the caps, as this was an integral part of the original agreement. Since Rachel planned to disregard this covenant, Henry may seek a declaration that covenant is enforceable, though the lack of a direct connection to the land may hinder this. In summary, Henry has a strong grounds to pursue enforcement of Covenant B through equitable means. The enforceability of Covenant A depends on demonstrating that Razel has assumed this burden or that it can be enforced through other equitable doctrines. Covenant C is likely unenforceable due to its nature. Henry should focus on injunctions for the active breaches and the clarifications on the enforceability of the covenants. Thank you.